So not all IRS representatives are the same, and it's important to know what type of IRS representative that you're dealing with. This isn't on a slide, by the way. This is a little pop quiz in the beginning. It's important to know what type of representative that you or the taxpayer are dealing with. So kind of look at who's who at the IRS. So I was wondering if there's anyone here who could give me what the main difference is between a revenue agent and a revenue officer. Someone knows?
Oh,
yeah.
I was a former special agent. So.
Oh, okay.
The revenue agent goes out and does the field audits and the examinations, and the revenue officer is typically in the collection area.
Yeah, that's correct. Okay, good. Yeah, so that what she was saying, that the revenue agent audits the returns, and the revenue officer is in collections. So, okay, so now I'm going to go through some of the slides, and I'll just talk about kind of 3 IRS representatives that you may come into contact with, and there's also more categories than these 3, obviously. But so first would be the revenue agent, and so the revenue agent, they examine or audit the tax return to determine the tax liability, and they're very highly trained IRS exam personnel, and the educational prerequisites include having a bachelor's degree in accounting or its equivalent. So when you're dealing with the revenue agent and you're a CPA, you're kind of a little bit, you're on the same page because you're both used to running numbers and figuring out what the correct amount of tax should be. And so the revenue agent is not involved with the collection of tax debt. They're just trying to determine the tax liability. Now the revenue officer, that's the person who's collecting taxes on behalf of the IRS. And they're assigned to the most difficult IRS tax debt cases where other collection activity, automated collection activity hasn't worked. And these are the people that have the power to levy bank accounts and garnish wages, file tax return, file federal tax liens, and seize assets. And so because they're concerned with collecting the tax debt, and they're not concerned with determining the proper amount of the tax debt itself, there's no accounting or tax background for these people. They're trained in collections. They want to get information like Form 433F, which gathers all kinds of financial information, so they can figure out what the taxpayer has, can they get the money, and how much can they get. And if they aren't going to be able to get any, then they're kind of close the case, kind of move on. And if the taxpayer is really uncollectible, because that's what their goal is, to just get as much as they can that they're allowed to get. And I didn't mention, because I was looking at the slide in front of me, it's right there, when I was talking about the revenue agent, as I said, they don't collect tax, they're not carrying firearms, they're not going to throw you in jail, they're not going to make arrests. Same with the revenue officer, they're not going to, they might threaten to throw you in jail, but they shouldn't, they can't. And then, so that's kind of like exam and collections. And then there's another category, the IRS Special Agents. That's the police force of the IRS. So those are they're law enforcement officers. So they're like police, and they're in the Criminal Investigations Division, CI division of the IRS, and they investigate tax crimes. And these are the people the representatives that would be carrying the firearms and would make an arrest. And I guess the best advice with the special agent would be if a taxpayer is contacted by one of these agents, and I think they typically travel in pairs, the taxpayer should refrain from talking to these people. Even if they say, we're not investigating you, you should still not say anything and lawyer up. I would say lawyer up. And consult with an attorney and just kind of make sure before the taxpayer possibly digs himself a hole. And what I've heard is often when a taxpayer is contacted by one of these special agents, they're probably the last one on the list to know they're being investigated, and they already have this big file built up anyway. So that's just kind of 3 different types of people you could dealing with the IRS, and just it's important to kind of know who you're dealing with. so that you know how to interact with them. And if I didn't cover somebody that you hear from, Google it and see what they do. And you'll be in a better position to negotiate with them if you know what they're kind of interested in. All right, so everyone has asked me what a tax controversy is, so I made a slide. But I'm going to just, I guess more general than the slide, I'm going to say a tax controversy is the name given to a tax dispute between taxpayers and taxing authorities. And that could be, for example, IRS, Franchise Tax Board, the Board of Equalization, State Board of Equalization, or the EDD. And it usually arises as a result of an audit, assessment, or collection activity that's initiated by the taxing authority. So with the federal tax controversy, it would be the tax authority is the IRS. And then a tax dispute could also be initiated by the taxpayer that is claiming a refund from the taxing authority. So it would be from the IRS in the case of federal tax controversy. And while the opposing parties in a federal tax controversy is always the IRS, they may be represented by different types of attorneys, but it's always the IRS. Substantive tax issues could be all over the place. They could be income, gift, estate, employment taxes. It could be anything. So there's going to be procedural issues and there's going to be tax issues, and you kind of need to have the ability to kind of understand both and understand the technical tax law and then all the procedural stuff as well, kind of work within that. So, okay, this is a slide I've used before. I think it's really helpful just to see. It's an overview slide of kind of the federal process of starting at the IRS audit, and then the next level up would be IRS, going to the IRS appeals. And then I was going to talk about different things that arise during each of these parts of the process. That's why I wanted you to kind of have this slide, so you could always kind of, if you want, fold the page and you could always look back at it as I'm going through. So these are kind of up here is administrative kind of levels. You're still within the IRS. Down here, you're in trial level courts, fact-finding courts. Here, you're in appeals, so you're not bringing in new facts anymore. You're kind of just arguing about how this court was wrong, or maybe the IRS is doing that, or DOJ, and then Supreme Court. So it's kind of the general overview of the tax controversy. All right. So with the IRS audit, and start real basic, that the IRS is examining or auditing the tax return to verify that the tax reported is correct. There's three types of audits. There's the correspondence audit, which is where the IRS sends mail to the taxpayer asking for information, and the IRS office audit, where the taxpayer goes to the local district office and talks to the IRS there. And then there's the field audit, which is with the when the IRS official would visit the taxpayer's home or place of business. Now, the field audit is sort of the most serious type of audit, and that's because it's less limited in scope than the other types of audits. And it's conducted by an IRS revenue agent who, remember I said it's the most highly trained exam personnel. And so these are the people that they're really sending out there for the big, like the important cases they're really looking at. These people out in the field. Whereas correspondence audit, that's where it's conducted by a tax specialist or a correspondence exam technician. And then with the IRS office audit, it would be a TCO, tax compliance officer. They're kind of lower down on the food chain of IRS representatives would be a way to kind of say that. Like there's a lot less. They still need to have the accounting background, but it's like 6 hours, not 30 hours. It's different. So when you're dealing with a revenue agent, you are really dealing with somebody who should be really highly skilled in what they're doing. Also, with the field audit, I would say that the taxpayer should request that the audit be held somewhere else, the CPA's office or the attorney's office. And yes, you can make that request for the taxpayer if you have the ability to do that. And that's with the power of attorney. You need to have a power of attorney to act as the taxpayer's representative for the IRS. And that's the IRS Form 2848. And be sure when you file power of attorney that you attach any existing ones to it so that the existing power of attorneys don't get revoked. if you refer your case to me or somebody else who's an attorney, make sure that they, once the client has engaged them, that they get a copy of your power of attorney to attach to theirs. Because sometimes it's really hard to get that power of attorney from the taxpayer because they don't really know what it is. They don't remember signing it. But that way your power of attorney doesn't get revoked. And I usually try and make sure that I ask them over and over again about it, but sometimes you're in a rush, you gotta submit one, and the next thing you know, the one that you already have on file might be revoked. So, all right, and then I just quickly was going over the attorney-client privilege, that only an attorney can give the taxpayer the attorney-client privilege. That means that attorney is exempt from testifying at trial. And I'm going a little fast because I'm getting to more interesting stuff soon. So there is a way that the attorney can bring a CPA or an appraiser or somebody who speaks another language under the attorney-client privilege to help the attorney with the attorney's client. And that extends the attorney-client privilege. It's not retroactive, so if you've already heard something, I can't cloak that under the attorney-client privilege after the fact. And then before I go to the next slide, just recent events, and just throughout my kind of tax controversy experience, I don't have a slide, but I made a note to myself right here to discuss retainers. And I was just going to say, as tax controversy attorney and somebody who works in controversies, that I really recommend getting retainers. When you take on a tax controversy, it's just that everybody's in a different mind setting than they are when you're just helping prepare the returns or doing some kind of planning where there's this whole positive just vibe with everybody. And I would say that there's just a really big difference in the nature of a tax controversy versus transactional. You say you are trying to help somebody with their audit, but you're not their regular CPA. Well, the moment they're done with the audit, they're going to go. They're not necessarily continuing clients. So if they haven't given you a retainer, you might not get paid. Another thing is it's not just about the money. I've learned that the taxpayer behaves a lot better when I have their money than when I don't. And that's particularly true with a collection type case because they tend to be flaky. They're in collections, they owe $100,000 to the IRS, and they don't seem really stressed about it at all, And so it's kind of, when you have their money and they know you're billing them and you're pulling it from that retainer that you've gotten, they're going to call you back a little bit faster than they would if they know that you don't already have their money. And so that's another reason to get it. And then be sure if you do some kind of retainer arrangement that you're clear that you're not charging a flat rate, because sometimes they think, oh, well, you've just given me an estimate, but that maybe that's just your retainer for kind of where you're starting for the audit, and then if it goes to appeals, well, you're going to require more, for that. And there's something called an evergreen retainer. I don't know if that's language people actually put in their agreements, but that's where you kind of have to the person has to keep replenishing it once it goes below a certain amount. It's just a good idea. I recommend it, having the retainer. And I wouldn't let the bill accrue, even if the taxpayer is expecting a refund, because the same thing, once the controversy is over, if they don't have particularly complicated tax returns going forward, maybe they just had some big issue the year they sold something, You just want to have that there, and it just kind of makes everybody get along better. And everyone's always happy to get the money left over from the refund than having a bill at the end, too. So, all right. So then I was going to give some tips on a couple things on the audit, during the audit, and that first would be to minimize the contact between the IRS and the auditor and the taxpayer. And then I think it's important to respond to the IRS within their stated deadlines. And if you need more time to respond, don't wait till last minute to request an extension. And this, I think, is really important because if the taxpayer doesn't respond to the IRS within that stated deadline and ignores the IRS, well, one, the IRS is more likely to extend the scope of the audit and just start asking more questions. So maybe the audit would have been concluded if they just provided the one thing right away. And the other thing that could happen is the IRS could just get angry and jump the gun and send a notice of deficiency. And then suddenly things are way escalated. And so it's really important to not ignore the IRS. And also, just as the taxpayer's representative, it's important to note that if you don't respond to the revenue agent or officer, whoever you're dealing with, that's hurting your credibility with the IRS, and that hurts your ability to represent that client and all your other clients that you have before the IRS. If you get a reputation as not responding to the IRS when they want you to. So you have to, I guess part of what I'm bringing into this talk so far is that you want to be concerned about the taxpayer, but you also want to protect your ability to represent that taxpayer and other taxpayers going forward. You have to kind of think of the whole big picture when you're handling tax controversy or when you're interacting with the IRS. Okay, and then also just be brief in your responses. Don't volunteer information not requested. I mean, unless you're trying to get another deduction, then put that right there. Give them that information, and to keep good copies or keep good records and copies of what you provide. And one helpful way to do this is including a transmittal letter when you respond to the information document requests, IDRs. And in that transmittal letter, you have to describe the documents you provide. If you just say, here are the documents you requested, that doesn't really help you with keeping a record of what you've submitted. It's just a poor tree that is turned into a piece of paper. So it's important to, I think transmittal letters are really helpful. It's also really helpful if the case escalates or you need to pass it on to another CPA or an attorney. It's nice to have good records so that they don't have to reinvent the wheel all over again. And then just noting that the IDRs at the start of a field audit, they tend to be broad, and then they'll start to get more focused kind of as the audit goes along, and so you kind of get an idea of what they're looking for. And finally, don't give your original documents to the auditor, because if they lose them, then the taxpayer won't have them to show that the expense was there if the receipt's gone, because they're not responsible for losing them. We think they should keep everything and have it all organized in their file, but human error, and it's not their responsibility to keep it. So I would not give original documents. I would always make a copy. Okay, so then once you've had your audit, there's the different ways the audit can conclude. First would be a no change, and that's where the IRS accepts the return as filed and taxpayer gets a no change letter. So that's really good news. Another way it could end would be a refund, and it's where the taxpayer would be due a refund as the end of the audit. So, and they get interest on that refund. So that's really good. And then agreed would be where the IRS proposes changes and the taxpayer agrees with the changes. And then a disagreed would be when the IRS proposes changes and the taxpayer disagrees with the changes. And of course, it doesn't have to be an entirely agreed case or entirely disagreed. There could just be some issues that everyone's disagreeing on. And so, so this is kind of just the breakdown in my mind of how I think of an audit ending. And let's see. So when you've got the disagreed, and the audit ends as disagreed, then the IRS issues a 30-day, they'll issue a notice to the taxpayer called a 30-day letter that has the findings of the examiner, the audit report, and the taxpayer's appeal rights. And I'm not going to, you've got that on your slide, so I'll keep going. So it's to appeal the examiner's proposed assessments within the IRS. Taxpayer has 30 days in which to file a protest requesting a conference with the IRS Appeals Office to discuss the disputed issues. And if the taxpayer does nothing, then the IRS would issue a statutory notice of deficiency, also called a stat notice, or IRS calls it a SNOD. I like stat notice. And I'll discuss that later. Okay, let's see. So if the taxpayer replies to the 30-day letter in a timely manner, then the taxpayer will usually receive a response from the IRS stating that they will transfer the case to the IRS Appeals Division, which is a separate part of the IRS. However, that's not always the case, and that seems to be becoming less and less the case. the IRS could go straight to the 90-day letter. And I've had cases like that. I have one just really recently where we responded to the 30-day letter, and the auditor was adamant that we mail it on the 6th of August, which was a Saturday. And I said, well, that's not the rule, but fine, I'll do it. So I did that, and then the tax bureau got a notice of deficiency in response. And it was, I'm sure it's going to be a real big mess because it's almost as if the government had disallowed everything on the Schedule C. So like all the expenses, phone calls, phone bills, everything. So there's lots of substantiation issues. I don't know if there really are any. In my opinion, there weren't really any legal issues there. So now they're stuck with tax court. So apparently this is not happening with just my cases. There's this, I have like a note, a printed part of an email, but there's this kind of, it's like a lawyer listserv I'm subscribed to, and some lawyers, they all kind of write into it. And there's been, I guess, it's been kind of happening over the country, it seems like, with appeals. And there seems to be a trend where they don't seem to be particularly proactive with cases. So it's really important to try and resolve what you can at the audit level. I mean, obviously, if you're not getting anywhere, then it makes sense, okay, then try and go up to appeals. But you might not get that appeal before you go to tax court. So it's still important to try and resolve what you can at the audit level. And I guess, well, what this one of the emails was saying that that part of the problem is they don't have the personnel or the resources that they usually have. They're short-staffed. And part of this is from the budget problems. And another problem is that they've just had a lot of retirements of the experienced staff. So they don't have a lot of experienced people working in appeals. And so even if you get appeals, you might get an hour with them, where you might get an appeals officer who's really stressed out and yelling the whole entire time because they just are really overworked. And one of the attorneys that wrote in that email thread that I was in, they had said that they had two cases that went to, it said they had two cases where the revenue agents did not audit the taxpayer, and they went straight to the notice of deficiency. And then after filing petitions in tax court, IRS, the chief counsel's office had to step in and tell the auditor to do the audit because they hadn't even done the audit. And so IRS counsel was, go do the audit. And it sounded like it was pretty, one of those cases, they said the revenue agent disallowed 100% of the expenses, and it involved real estate and disallowing property taxes even. I mean, it was just, so there's just something that's not so great. They're just really understaffed. But yeah, sorry, yes?
I mean, I think maybe I'm wrong, Chief, you can help me, but I think we've seen things like that simply when the client doesn't respond at all to anything. Mm-hmm. It just marches through the process, and pretty soon you're at the 90-day letter, and client's, well, I never got anything. And the IRS did not do anything because they said, unless you respond, this isn't valid, and then no one responds, and they keep going. So pretty soon. Yeah,
it's like, I think they're short-staffed. It sounds like in an audit even also too. I mean, I guess maybe that would be if Hillary wins, then maybe our business will increase.
I mean,
or mine will.
The taxpayer has to respond.
Right.
Or you can't necessarily blame the IRS for marching down this order.
Right. Yeah.
That's where I think what you're just read about came from.
Sort of.
Nothing.
Well, sort of, but actually, the one attorney that was quoting that email he was saying that the auditor was assigned the case and didn't even do the audit. They must have just sent some welcome to audit and then just notice deficiency. In my case, we provided a couple hundred pages of receipts and a very concise letter that explained the receipts, and they issued a notice deficiency. And I mean, it just made no sense. But yeah, it's like you definitely don't want to ignore them because that would bring it up. Okay, so that's why I said they usually receive a response saying that goes to appeals, but it might not. All right, so once an appeals officer is assigned to did I talk about the protest? Yes. Okay, so once the appeals officer is assigned to the protest, or I'll just call it the appeal. Typically, it's a protest when I'm doing it, formal written protest. There's other cases where it's a small enough dollar amount. Maybe you don't need it to be in writing, or there's more informal protests. But probably everybody in here, if we're handling an appeal to the IRS, we're probably doing a protest, a written one. So once it's assigned to the appeals officer, they'll receive the file, including the protest, the audit report, etc. And they'll determine whether they need more information from the taxpayer and schedule a conference with the taxpayer and or taxpayer's representative to discuss the protest. I guess another thing to throw in here would be it's good to have sometimes your power attorneys on file, then you'll get copies of these notices. Sometimes if you have clients that travel a lot and don't check certified mail, you could miss out on certain documents that are important. Although I don't believe that the radio letter comes certified because it's not a statutory letter. There's certain letters that you definitely don't want to miss that come certified. There's certain types of collection letters that give you certain rights. If you don't accept the letter, it doesn't matter. What matters is that they prove they mailed it. So I would always accept anything certified by the government. All right. Like, I have a collection case where they didn't accept it and they lost their collection appeal rights because of that. So, all right, when you're with the appeals office in IRS, the conference is typically informal and it can be conducted by phone, in person, or by mail. Unlike a revenue agent, the appeals officer considers the hazards of litigation for both sides in evaluating the case. So when you're dealing with the revenue agent and you start talking about, oh, you were going to lose at trial, they don't care. They don't care if the person doesn't even have the money to pay it. They should care, but that's not part of what their job is. And most matters will be settled at the IRS appeals level. Okay, I should speed up. Yes. Oh, sorry. Yes.
Did the appeals officers get together and have discussions about the hazards of litigation, or is it a individual by individual basis?
I would think that the appeals officers, they could talk to each other. They're not supposed to talk to exam without you. But I never worked in the government side first. It's unusual. I've always been on the taxpayer side, but I seem to have had a lot of cases that have gone pretty high up in the process. One went to the Supreme Court. So I've had a lot go really high up, but I mean, it would just be me guessing, but I don't see why they wouldn't bounce ideas off each other the same way I do with people here. And then they also would probably have their supervisor, their manager above them. So, but I don't know if the hazards of litigation are really going to help that much. There's something, well, if I make it to my last slide, if I don't, I'll jump to it, but I have there's a way sometimes you can kind of force them to consider the hazards of litigation, like really consider it with attorney fees and stuff, but that's like later in my discussion.
I've got 3 separate clients that are at appeals right now, all for the exact same issue with 3 different auditors.
Uh-huh.
So we had our first appeals conference on Thursday, and it went really well.
Uh-huh.
So I'm trying to figure out if I can get the other 2 to be part of that same appeals. It has to do with R&D credits and whether they're allowed for a particular industry or not. And so the IRS came in, audited, said, no way, R&D doesn't apply to this industry, so they disallowed the credits.
Mm-hmm.
So we're all in appeals right now. The first conference was Thursday, and like I said, it went really well. So I just wonder if they talk to each other.
Are they assigned to different?
One person's going to say yes, the other one's going to say no, and it's the exact same issue.
Are they assigned? They're assigned to different appeals people.
Yes.
Well, I don't know if it would help, but I would say I would always put stuff in writing, but you could try and write and make a written fax or request, but put it in writing and try and put something in writing, because that way I feel like if you put your request in writing that maybe they're all considering it together, it goes to one person, it's hard for them to say it didn't happen or to ignore it because you've done that in writing. But
like I said, if one person agrees and the other 2
Yeah.
don't agree, or 2 agree and one doesn't agree, I'm going to have a mess.
Can you mention it? Can you mention it and say, hey, why don't you go talk to your colleague next door?
I'm a little worried I won't make it through my slides,
Sorry.
so I should keep going. But I can totally talk to you about this more.
Okay.
It's interesting to me, so, and I think it's interesting to other people. Maybe I'll have time at the end, but I just want to get through a couple or try and get through them. But yeah, I can say though, from like a lot of the litigation I've had, when I had a lot of cases where I used to work that, and because a lot of my cases now are newer, so I have less that are at court level. But I had a lot of cases that were in court, and I think that the IRS and we are both just kind of making up the law as we go along. We had these people elect out of a partnership proceeding, and that was really good. And then another case, the IRS argued, well, they elected out, so they're actually like, and they were using our arguments against us, and then we did it against them, and it's just kind of like you get to this point where it's just everyone's kind of making it up, because you can't have every situation is always going to be a little different. Yeah, you can have 3 clients the same, but there's always going to be something that's going to be almost the same, but just slightly different. So, okay. So I'm going to keep going with my slides, and so we're kind of still in the, there hasn't been an assessment yet, because we're still in appeals with the discussion that we've been having. So I thought I would talk a little about statute of limitations for assessment. That's where the IRS, they typically get 3 years from the date the return was filed to make an assessment. And there's 6 years in the case of a substantial admission, and that's when the taxpayer leaves off more than 25% or more of their gross income from, sorry, I keep reading the slide, but I don't need to. It's just right there. So if you admit more than 25% of the gross income stated in the return, they get 6 years, and it's unlimited if there's an unfiled or a fraudulent return. So it's always important to get that return filed, to get that statute.
Can I answer this one?
Sure.
So we have a client that got the partnership got audited for 2011, and then we opened all the partner and assessed the tax. And then we finally realized that the K1 is filed in 2013, but all the partner statute of limitation already expired. What can we do in that case?
Oh, there's so many cases on I couldn't answer it on top of my head right now, but I could just say that I know that there's there's different rules where it's kind of, if there's something from the partner's return that's part of that proceeding, that there's a way that there's something open in statute. I'd have to look. I don't know. Do you think you could ask me later on it?
Sure.
But yeah, I mean, I can talk after this. But okay, I'll keep going. But yeah, there's weird rules. I wonder what's going to happen when TEFRA goes away, if that's going to make these cases go away. You know. But yeah, I can say that it is sometimes you can, I wouldn't say it is legal advice, but sometimes a good jumping point is a Google search and you find an article that's written about what you want. And then with me, it puts me in the right direction of case law, and I just keep going. And so sometimes that's like, with the internet, it's really good to find that, but I'll get back on that one. I just want to, keep going through these. So when you got the statute of limitations, it can be extended by a written agreement between the IRS and the taxpayer, and these agreements are called consents, and the IRS has forms for them. And there's 2 basic kinds of consents. There's a fixed date consent, which sets a specific expiration date for the statute of limitations, and an open-ended consent, and that has an indefinite length of time. There's also a restricted consent, which can be either fixed date or open-ended, and that limits the further examination to specific issues. So you could make it really narrow, and it's probably a little harder to get the IRS agreeing on that. So the question is, should you extend the statute of limitations? And so what I say is, the way I look at it is, if there's legal issues, only legal issues remaining, it doesn't make much sense to extend the statute of limitations. If there's factual issues, then extending it might make sense. And then factual issue would be, you look at the facts to resolve that issue. If it's a legal issue, you're going to look at the law to resolve the issue. So in a substantiation case, and the taxpayer is trying to get some documents to prove some expense, some really big expense, it has to be big enough to be worth extending the statute for, then it might be a good idea to extend the statute of limitations. But if you're just arguing with the auditor about whether or not something really is a legal expense, or really is a business expense, and you've already proven that amount's been paid, then I would say it's not worth it to extend that statute of limitations, because you're not dealing with a lawyer. You might be with the revenue agent. Some of them are CPAs and some are lawyers, but it's probably better to let that kind of go up higher in the process. And so, for me, I would rather not extend it. Okay. So I also have just another slide I added in. It's just kind of let you know that even though we're discussing what happens when you have the income tax audit and there's where you get to do the 30-day letter, the protest in response, there's also other ways that cases get before IRS appeals. And there's other, like IRS determinations they hear. And some of those include the proposed assessment of a trust fund recovery penalty, TFRP under 6672. That's when the employer has not paid when they withhold money, when there's withholding from the employee's paychecks and the employer holds that money in trust and they don't pay it to the government. And then if the government can't get it from the employee, like the company, they'll go after responsible persons. And so it's called the trust fund recovery penalty. And so appeal, if the IRS proposes assessing that penalty to your client, this is something that could be appealed to the IRS. Also, issuance of a lien or proposed levy or seizure, and there's a different type of response, but still an appeal to the IRS. It's be a collection due process hearing, or it's called an equivalent hearing, but it's something else the IRS appeals handles. And also a proposed rejection by the IRS of an installment agreement or an offer in compromise. So those are all things that could come under the jurisdiction of appeals, and there's others as well. So say we're back in our scenario kind of we were following, where we have the taxpayer has filed their protest in response to the 30-day letter. They had the appeals conference, and so now actually I guess I started with a couple other things, but next step in the process would be when there is a notice from the government of the deficiency, so the 90-day letter. And so if the taxpayer doesn't respond to that 30-day letter, or is unable to reach agreement with IRS appeals following the protest, or that statute of limitations is about to expire and you're not willing to extend it, the IRS will send the taxpayer a statutory notice of deficiency, commonly referred to as a 90-day letter, SAT notice, SNOD. And of course, it is possible that they won't issue this notice and the statute will run. That does happen, but it's not something I would count on, but it does happen. And often, if it does, the government will try and figure out a way to get you into that 6-year statute if they can. So the notice of deficiency is, everyone calls it the ticket to tax court. And that gives the taxpayer 90 days within which to petition the United States Tax Court to redetermine the deficiency that's proposed by the IRS. And it's 150 days if it's mailed to the taxpayer outside the IRS. Now, it's really important to always remember that the 90-day period cannot be extended at all. So you can't ask the IRS to extend that time period. It's 90 days or possibly 150 days. It cannot be extended. And during the 90-day period, the IRS is barred from making an assessment or any collection activity. But if you fail to file that tax court petition with the tax court within the 90-day time period, that will result in the deficiency being assessed. And if the deficiency, kind of interchange the words there, so deficiency, liability, if it's assessed and the taxpayer does not pay that amount of the assessment, the IRS will begin collection activity. And I will put up another slide. So this is statute of limitations for collection as opposed to assessment. Assessment is kind of where the IRS puts it on their books. And then collection is, okay, now it's on the books, let's go collect it. So typically the IRS has 10 years from the date the tax is assessed to collect the tax. I think California, it's 20 years, which is much longer. And there used to not even be a statute for collection with California. So that statute's a very new statute. I don't think it's been tested yet. Nobody's been able yet to claim it's run because it's new and it's such a long time period. But so anyway, at the IRS, it's 10 years. However, certain taxpayer actions can extend that collection period. And that would be things like filing a bankruptcy or an offer in compromise or a request for innocent spouse relief or a timely collection due process appeal. Any of these things prevent the IRS from collecting, so the statute is told. And it's important when you're thinking of ways to resolve what I call collection cases where the taxpayer has debt with the IRS. But yeah, offer in compromise sounds like a great idea, but it takes typically at least 9 months for them to even look at that. So the whole time you've filed that offer in compromise request with the government, the statute, that 10-year statute's not running, it's on hold. It's just sitting on hold. And meanwhile, the person's probably not making payments. Everything's getting larger with what they owe. And so it's not always the best method, especially if the taxpayer has property with a lot of equity in it. There's just the whole reasons why it might be denied. It's not sometimes a regular installment agreement is just much safer, and it won't toll that statute once you're in it. While they're considering it, it'll be tolled. Okay, and then even though the 10 years, so say the 10 years, it still could be extended, but it's extremely unlikely that the IRS can sue the taxpayer for a judgment in court to get more than 10 years. And that's similar to when like a credit card company even would reduce the debt to a judgment. So the IRS can do that too. All right, so how am I on my time? Okay, appeals to the federal courts. So it's known as judicial review. Taxpayers may request judicial review of IRS determinations by filing the petition with the tax court, with that 90-day letter, right? Or U.S. District Court or the Court of Federal Claims. And the tax court it's a court of limited jurisdiction. It's created by Congress under Article 1, so it's not in the judiciary branch. And they hear tax cases. And the tax court, unlike other judicial venues, it does not require the taxpayer to first pay the amount in dispute in order to file suit. And that's an advantage of the tax court route. And then the tax court is in Washington, D.C., and the judges travel around the country, and they travel to a bunch of designated cities. And I think there's a slight, well, you can find this on the tax court page, but some of them are just for small S cases, the under $50,000 type cases. So that's where the judges go, but the court is headquartered in D.C. And then in tax court, there's no jury trial. The case is tried before a single judge with expertise in tax law, and it has its own rules and procedures that supplement the federal rules of civil procedure. The IRS is represented by Chief Counsel's Office, IRS Counsel, is what I call them. And unlike other judicial forums, non-attorneys can represent taxpayers in tax court, but only if the non-attorney is admitted to the U.S. tax court bar. So to get admitted to the tax court, attorneys must submit an application, a fee, and a letter of good standing from the appropriate bar. So I do have multiple bars, but say I could get a letter from California Supreme Court, my highest bar, get that letter, and saying I'm in good standing with the bar, and that's what I would be submitting. For a non-attorneys must submit the application, a fee, and they must pass a written exam that's given by the court, and they must also be sponsored by at least 2 persons that are already admitted to the court. And I have to say that the stats aren't so great, but attorneys represent the majority of those admitted to the tax court bar. And you can see from this, I found this in the tax court webpage. I'll give you more detail if you want where I got the statistics from so I don't run from time. But from 2004 to 2012, there were 37 non-attorneys admitted to the tax court bar, and there were 9,738 attorneys were admitted. Now, there are CPAs that are lawyers, so then they would probably get admitted under the attorney route, not take that exam. So this number, 37, is not quite as low, but if you are a CPA and you're admitted to tax court and you're not a lawyer, you're special. You're one of those 37 people. Or I guess whoever else came in the last, because this statistic only went through 2012. But it's a lot. And part of the reason I think the difference is there's such a big difference is because the pass rate is not so great. And there's this, the tax court publishes this, so you could pull it up in an online search or look at my slides. I'm going to keep going. But you can see that the pass rate 2014, 126 took this exam, 23 passed it. Part of the reason it's so difficult to test you on tax law, substantive tax law, test you on the rules of the court, test you on evidence rules, it tests you on professional responsibility. It wants to make sure that you know the tax, but you also, the procedures, I think the procedure is a lot more important. I have to learn tax law for each case I'm in, and the procedure is kind of similar throughout. So I just have, being the attorney is really helpful once you're in tax court. Okay, and let's see. So generally, a case petitioned to the U.S. tax court will be considered for settlement by an IRS appeals officer before the tax court hears the case, but it'll be a docketed appeal. That means if there's a settlement reached with appeals, the IRS counsel must agree to that. So this is another reason why you go to tax court. So say they jump the gun when you're in an audit and you don't get to go to appeals. Well, when you go to tax court, ideally, once the IRS counsel has the case, they'll send it back to appeals to try to get it resolved. I think appeals actually has almost exclusive jurisdiction in the first 4 months. I read that somewhere. So I think they do have a policy even where they're trying to get appeals to look at it. Although appeals is usually not so interested in your case until it's calendared, because, like I said, appeals is kind of understaffed right now. So in tax court, the case is commenced by filing the petition and timely petition, a filing fee, a statement of social security numbers or EIN, and then where you request where you want the trial, you pick one of those cities. And sometimes you need an ownership disclosure statement. That's for certain corporate taxpayers. So then after the petition, IRS answer, and if a reply is required, the case is considered at issue, and pretrial discovery can begin, and that's typically when it gets kicked back to IRS appeals. All right, I'm going to go. So another venue would be U.S. District Court. Difference with district court, tax court, main difference, taxpayer must first pay the disputed tax liability and file a claim for refund of tax prior to filing the lawsuit. You could have a judge or jury trial, and DOJ tax is who's representing IRS, not IRS counsel. And then similarly, the U.S. Court of Federal Claims, that's the other venue you can go to. It's a special limited jurisdiction type court. It's designed to hear claims against the United States. Tax claims fit in that. Just like district court, taxpayer must pay the disputed tax liability, file a claim for refund of the tax prior to filing the lawsuit. There's no jury. IRS is represented by DOJ, Department of Justice. And one thing unique about the Court of Federal Claims is that the appeal will always go to the federal circuit, whereas other courts will go to whatever circuit court is in the geographical area where the taxpayer is. I'm not going to go into detail on that. So filing a refund, generally taxpayer has 3 years from the date the original return was filed to file that claim for refund, or 2 years from when the tax was paid, whichever is later. So sometimes this works out in the taxpayer's favor because they don't pay their 2008 tax till 2015, and so they have a lot more time to file that refund claim, whereas had they paid it in 2008, then the statute has run. So sometimes it helps out when they haven't paid, but I would not recommend not paying. Okay, and then filing the suit for refund is, so once you file this refund claim, you have to do the refund suit within no later than 2 years after the IRS has rejected the claim. But if the IRS sits on it for 6 months, you can go to district court. And so, okay. So how am I on time? Okay, good. I just have a little bit more. So, I'm going to talk about something happy. Taxpayer recovering fees and costs from the government, when they're successful. So there's the IRC, so Internal Revenue Code, Section 7430, that gives taxpayers a right to recover reasonable costs, including fees of experts and attorneys paid in connection with certain federal tax controversies, giving a very rough description of all this for you. So there's a lot more detail in it. The 7430, it covers both litigation costs and costs incurred during administrative proceedings. It's extremely difficult for a taxpayer to recover costs. So before I go to my next slide, as discussed earlier, the IRS uses a 90-day letter, stat notice, to inform the taxpayer of what the IRS has determined to be the taxpayer's liability. So there's something called a qualified offer, and that's kind of that is the taxpayer's 90-day letter to the IRS. So the qualified offer provisions in 7430, they provide the taxpayer an ability to send their own 90-day letter to the IRS that offers the IRS what the taxpayer believes to be the correct tax liability. And if the IRS doesn't accept the taxpayer's qualified offer within 90 days, and then judgment awarded to the IRS is smaller than the amount of the qualified offer the taxpayer had made, then the IRS is on the hook for the taxpayer's reasonable administrative and litigation costs, such as attorney fees. And I said reasonable, so if your rate is $400 an hour, reasonable is maybe $180. I think it's defined in the code. of what the person would get back. And their qualified offer must be in writing. There's a whole bunch of timing requirements on it, and so it's a lot more complicated than that. But it is it's a really good strategy because it increases pressure on the IRS to settle the case. It creates a potential for the taxpayer to impose costs on the IRS when the IRS refuses to accept reasonable settlement offers. And a case with a qualified offer should, jump up that list of the to-do list for the government, whether you're dealing with DOJ, Department of Justice, or IRS counsel. And because if the IRS doesn't act quickly, they may have to pick up the tab for the taxpayer's fees. And as an example, I had a recent tax court matter where taxpayers were clearly correct. They were clearly correct, and I made a qualified offer to the IRS counsel for $1 because I was trying to get their attention. And within less than a week, I was contacted by IRS Appeals, and the case settled within the 90 days, and the taxpayer owed nothing. But like I said, that case, I knew the taxpayer was right. It just sometimes it just goes up in the process and just it doesn't get caught, and it's computer errors and stuff like that. So anyway, it's a really good qualified offer. Is kind of gives you some leverage in negotiating with the IRS. So that's where my talk ends, ending on a high note, where you maybe get the money back, and then the taxpayer is really happy. So that's the end, and I don't know if anyone has questions. Hope I didn't talk too fast, but I had some questions in the middle that I'm happy to follow up on. But does anybody have any more? Okay. I was trying to talk really fast. All right, well then I think, that's all for my talk.
Hey Lauren, did you talk about that issue about how you don't get attorney's fees if you do it in a setting, go directly to DOE instead of going through appeals?
Oh, yeah, well, so that was with the state. So that was what I was saying when you go back to here, under 7430, there's all these requirements in there. You have to exhaust your administrative remedies. You have to meet certain net worth requirements. So I guess, what I was talking about with Fiona earlier was that when she was saying, go to the board, I thought, well, if you jump to the board and you don't exhaust all your available administrative remedies, so now we're talking California, then you can't try and get the attorney's fees from the government. And what I've learned is that the government does not want to be on the hook for attorney fees. They really look at the issue really closely. So if you were to skip a part of the process and go straight to the board and you had an opportunity to file the protest and go to an appeals part before you go to the board of equalization, because that's still administrative. It's not a tax court. It's still part of the administrative proceedings. If you jump to that, then for the rest of the case, the IRS would kind of know, you didn't exhaust your remedies, so you're going to have you won't really be able to get attorney fees. And so you lose a lot of leverage in that. That's kind of what I was talking about with Fiona. I was just asking her, well, they kind of know that, so they kind of keep you in protest, it seems like. And yeah, that was kind of what that was. So yeah, there's a bunch of requirements under 7430 at the federal level, and you have to exhaust your administrative remedies. So the case where the government maybe goes straight from the audit to the notice of deficiency, well, you don't have to file a protest because you can't. So there's nothing to exhaust. You've exhausted all available remedies because they never gave you a chance to go to appeals. So it's really based on what the taxpayer chooses to do by what's available to the taxpayer. Okay, any more? Oh, yeah?
Yeah, I end up doing a fair number of reasonable cause letters for people who've got the $10,000 penalty assessments for international delinquent forms. And I don't know, the IRS seems a bit schizophrenic on this because they'll give it away if you self-remediate, but if you file a tax return and a day late, you've got a problem. What's been if you're doing this kind of work, what has been your recent experience in trying to get those penalties abated for reasonable cause?
Well, that I've seen that 10,000 penalty, but usually when it has only come to me with just that, the person hasn't been willing to pay the retainer for me to do it, so I haven't taken it. Yeah. But I can say that with the reasonable cause, I've had it work. I had it work I've had reasonable cause work with the reliance on the tax professional. I've had that be successful. It's not with that penalty, but it's with the accuracy penalty. It's just like I have a reasonable cause type argument where I was able to, it was very technical, really complicated. It had to do with the taxpayer getting the property through like a part gift, part sale. So there was a whole issue about the basis, calculating the basis of the property. And the CPA used the refi basis, the refinancing basis. So they didn't use the right number. But the taxpayer had given all the documents they could to the CPA, and so I was able to get. I had luck with reasonable cause there.
Yeah.
I mean, there's also. I don't know. I don't think the first time abate probably doesn't work with. I don't know if it works with that, but I don't know if you've ever tried first.
Whenever I can, right?
Okay.
But usually you can't do that.
Because it works over the phone.
Yeah, well.
You have to tell them that their revenue manual
phone.
got rid of the minimum amount, so I got a $21,000 penalty waived on the phone.
It'll work on the phone.
Yeah.
If they meet the criteria, but if.
And it doesn't waive interest though, so they still get hit with a really big interest amount sometimes.
No, I don't really care about the interest.
What's the reasonable cause that you put on your letter?
Well, yeah, so everybody asks me if I've got a template, and I tell them to tell the truth. Everybody's reasonable
I
cause is a
told
little
them the
different.
truth and never fail.
They're like,
Well, yeah, those are tough clients to serve.
I think my interest was the case I had. It was 16,000 interest, 24,000 penalty. So it's like sometimes the interest is high because it was a sale of an option. So it was kind of like they had all this gain. So sometimes it's a big number. Yeah, usually not like that. But I would say reasonable cause. I mean, I'd say if you have a lot of luck with it, you could publish something on it probably. Because I think there's a lot of discretion with the people reviewing it until you get it high enough up. Have you ever taken?
I've had the experience where everything is getting kicked up to appeals. The people at the appeals
Yeah.
level actually aren't the ones addressing the letters.
Because they can't do the hazards
Sending a
of.
second letter,
Right.
the third letter taking too long.
Have you met with appeals on it before?
No, I haven't yet, but we did have one situation where it honestly took a year to resolve. And
That's faster than going to court, though.
We agree with you,
Mhm.
but it took a year to get there.
Yeah, I guess it's because appeals is considering hazards of litigation. I mean, you could look into I mean, a qualified offer might work in that kind of scenario too. But you have to have a letter that gives you a right to go to appeals before you can make that qualified offer. But once you're at appeals, you could do a qualified offer. They do take it very seriously. They monitor it. They keep talking. Every phone call they mention it, that we're talking because of this qualified offer. So yeah. It is really interesting. Yeah. Okay. I don't want to take your time.
All right.
Yeah. And I know I had some questions.